Hi, everyone. Welcome and thank you for joining. We will give everyone a few minutes to file in and get started here soon. Okay, it looks like most people are in, so I'll go ahead and hand this over to Elissa.
Great, thanks, Lynn. Good morning or good afternoon, everyone, depending on where you are. It's still morning for me. I'm Elissa Taub. I am a partner with the immigration law firm Siskin Susser, and I am the leader of the firm's healthcare immigration team. I'm also the co-author of the Physician Immigration Handbook that many of you may have a copy of. This year, it's out in its 10th edition, so we're very excited and proud about that. Today we are going to talk about all of the hot button things that are going on surrounding physician immigration. This is where I live my days, so that maybe you don't have to. So we are really going to dive into all of the things that I'm hearing from recruiters on a daily basis with questions, confusion, concerns, and we're going to kind of go through all of those issues. Before we dive into the substance of the presentation, just a few housekeeping things. In this meeting, there is a chat and a Q&A. If you can put your questions in the Q&A and leave the chat for things like technical issues or things like that, that would be great. I'm going to monitor the Q&A during the presentation. So if you ask a question that's relevant in the moment, I'll be able to answer it in the moment that we're discussing that topic. Otherwise, what I'll do is I'll hold the question till the end and kind of come back and make sure I haven't skipped anything. As a lawyer, I need to advise you that this is not a confidential setting. So we want to make sure that any questions you're asking are not case specific and are a little bit more general, not necessarily specific to any one candidate or any one organization. And also many of you may be represented by other lawyers. And of course, I don't want to give conflicting advice on specific cases. So general questions are great. I want to make sure that you all leave here today with a good understanding of these issues and are armed with information to kind of go back to your organizations, your candidates, your existing international physicians, and help this inform the policies that you're implementing, helping you answer their questions, just kind of knowing and feeling more comfortable with where things are going. So on that note, let's give you a little roadmap about what we are going to cover today. We're going to cover this in like 6 big chunks. We're going to start with the thing that I get the most questions about every day, which is the $100,000 H-1B fee. We're then going to pivot and talk about some other notable updates in immigration, things that don't really fit into any particular buckets, but are important to know about. We're going to talk about the travel bans and the USCIS benefits pause. We're going to pivot from that into other risks of travel, updates on J-1 waivers, specifically some of the federal waiver programs. And then we're going to talk about something I'm getting increasing questions about, which are the different alternative licensure pathways that some states are providing for international medical graduates, and the interaction between those licensure pathways and immigration, which are not always, they don't always mesh together. So we'll talk a little bit about that to close things out. So this is where we're headed. So let's get started. The $100,000 fee. I think probably every single one of you sitting on this webinar today, either in the front or back of your mind, is like, maybe she'll talk about this. So to give you a little bit of a history lesson on where we've been and where we are, obviously on the slide, you have some basic information. On September 19th, 2025, the president signed a proclamation that purported to attach an extra $100,000 fee to every H-1B petition. And really, it even said visa. The proclamation itself, the wording was really awkward and imprecise. In the days that followed, the chaotic days that followed the signing of that proclamation, we were hearing all different kinds of information from the administration, in the press, about, well, this really, here's how this is going to work. All of it was messy and not really accurate. About a month later, on about October 20th or so, on the USCIS website, all of a sudden there just appeared some additional guidance about how this fee was going to apply. And that is still the same guidance that we are operating under today. It has not changed since mid-October. And basically the crux of this is that the $100,000 fee, if you think about this, it applies to people who newly need H-1Bs who are coming in from outside the United States. So if you're filing an H-1B petition for somebody who is abroad, the fee applies. If you're filing for somebody who's in the United States, but they leave while the petition is pending, USCIS might say, oh, that person departed, now you need to pay the fee. If the person is inside the United States when you file, but we know they're going to have to process abroad because they're not eligible to change status in the United States, the fee applies. Or if the person has violated the terms of their status, if their H-1B for some reason was filed late, something like that, and USCIS in their discretion says, no, this person's going to have to make a trip abroad and come in newly, they're going to ask for the fee. So the essential trigger mechanism for the application of that $100,000 fee is the need for someone to make a new entry into the United States to make that H-1B effective. So conversely, if somebody's here in the United States and they are eligible to change status, like from J1 to H1B, change employers, if they're already in H1B status, have their H1B status extended or amended without stepping 1 foot outside the United States, the fee doesn't apply. So we are filing H1Bs every day without need for the fee. I have 2 of them sitting on my couch right now. Fee won't apply. It's really triggered by the people who are going abroad. For physicians, the one place that this has probably been the most disruptive is for Canadians. Some of you may know that a citizen who's in the United States on a J1 sometimes can, initially at least, bypass the need for a J1 waiver and jump right to an H1B. Let's say they sign a contract with an employer after that state's J1 waiver program is full for the year. That Canadian citizen historically we could get an H1B approved for them. They'd have to tag up in Canada, turn around and come right back in to start work, because without the J1 waiver, they can't change status inside the United States. So they necessarily need to make that trip. The $100,000 fee has largely ended that workaround. It's ended the ability for us to use that exception for Canadians to at least initially bypass the J1 waiver, get them on the H1B, and then maybe apply for the waiver later. For some of those doctors, we're using O's as an alternative, but for others, we need to send them to another employer so they can get a waiver, because they can't just jump to H1B anymore because of the need to make that trip. So to me, in my practice, that's the most obvious place where I'm seeing the $100,000 fee come into play. If the fee applies, the payment has to be made before the H-1B petition is filed. And I've had a couple of clients go through this process, so I have seen this in play. There's a special link at pay.gov. The fee is paid. We print out the receipt from pay.gov that shows that the fee was paid, and we include that receipt with the filing of the H-1B petition. If you look online, if you read the USCIS website that relates to H-1Bs that has all of this information, they also talk about how you can get an exception to the fee and how to apply for it. There's a special email box and 4 prongs that you have to prove. About 2 Fridays ago, pretty much every single pending request for an exception was denied with the exact same language en masse on the same day. Lawyers around the country, we all got the exact same email. there have been no exceptions to the fee that have been approved. They've not been approved for individuals, they've not been approved for occupations, and they've not been approved for industries or employers. So you may have heard in the early days of the fee being a thing that healthcare workers were going to be exempted from it, and that's just not true. They are covered by the fee the same way anybody else is, at least for now. There was a bill introduced in the House of Representatives a couple of weeks ago with 2 Republican and 2 Democratic co-sponsors, led by Representative Mike Lawler from New York, that would purport to exempt nurses and doctors from application of the $100,000 fee. I'm a little bit negative on expecting Congress to actually pass a bill that might be helpful for immigration purposes. So I'm a skeptic on that, on whether that's actually going to be passed, but it was a nice show of support. And one of the things I'm hopeful for is maybe after, a tremendous outpouring of advocacy from the healthcare community, perhaps maybe the White House would see this as a little bit of a push, like, this is really affecting the industry. We need to provide an exception here. But so far, that has not happened. A couple of other things I wanted to update with regard to the $100,000 fee. There are 3 lawsuits pending that challenge the president's authority to be able to implement this fee unilaterally without Congress. They're all in different procedural postures. There is one case pending in DC that was brought by the U.S. Chamber and the American Association of University Professors. There was a negative initial decision there, and that's up on appeal. I expect we'll hear back on that appeal soon. There's a case that our law firm is involved in, which is the Global Nurse Force case, which is a class action pending in the Northern District of California. There were oral arguments in that case on February 26th, and we know a decision is probably coming on that imminently, maybe today. So we'll see on that. And then there's a case that was brought by about 19 or 20 states that have Democratic governors that challenge it from the state level. That's pending in Massachusetts, and that was the last of the 3 cases that was filed, and it's a little bit behind where the other cases are just, procedurally. So we'll see. There's still a chance that any number of these lawsuits can come out positively for us. And then the last, what was interesting during our oral arguments in February, the government revealed that about 7, as of that point, as of February 26th, about 70 employers had paid the fee, I think, for about 80 employees. And that's nationwide, right? So if you think about the number of, thousands of employers nationwide hire H-1B professionals, thousands of employers may be affected by this, but only about 70 of them actually paid the fee. So it's a very small number. So for those of you who may be trying to formulate policies on how your organization is going to deal with this, if many folks have just said we're not paying this, which is understandable. If you're trying to be more nuanced about it, there's not a lot of competition in the marketplace for other employers, rolling out the red carpet and just doling out $100,000 fees, right? So, if you're, interested to know about that, there aren't a lot of folks clamoring to pay the fee. Let's see. There was one other thing. What was the last thing? Oh, the other last thing I wanted to mention about this, and we'll move on to the next topic, is technically, the presidential proclamation that created the fee expires on September 21st, 2026. So, for H-1Bs that you may be looking at filing for the fall, as of like right now, you could, there's a potential argument the fee wouldn't apply because it's expired. We fully expect the administration to re-up the proclamation. We don't think that they're going to just let it expire. So, we're being, hyper technical from a legal perspective, looking at the expiration of the proclamation. I expect that as more lawyers, as more folks post about the expiration of the proclamation and, try to get around it by saying, hey, it's going to expire, that that over time we're going to, see the administration extend the application of the proclamation. And maybe the one thing that will keep them from doing that is if there's a negative court decision. But, all of that needs to play out in the months ahead. And I see that Anamar from Cincinnati Children says that they still have an exception request for the $100,000 fee that's still pending for months, and they have not heard back on theirs yet. So it may not be that all of them were denied a couple of weeks ago, but ours was filed, I think, November 10th, our first one, and that was denied summarily in the whole fell swoop with all of the other ones. So there were a bunch of denials just a couple of weeks ago on those. So yeah, and I will say there are healthcare employers that have paid the fee. Not a big number, right? If it's 70 nationwide, that's not healthcare, that's 70 employers, but I do know of several that have paid it. But this is not, there were, in my experience, those were very special circumstances that caused those employers to pay. They are not looking to do that prospectively necessarily. A lot of times these were folks that were already under contract, expected to start imminently, and that was the only way that they could get through the process. So very specific circumstances in each of these situations I'm aware of, both with my own clients and with others. So yeah, there have been a few healthcare employers that paid, but it is not I would say that that's not a trend of healthcare employers wanting or able to pay the fee. So that's where we are on the $100,000. As the H-1B cap lottery just finished this week, which actually helps us transition to our next slide. There will be more employers that are going to pay the fee over the next 3 months. The H-1B cap lottery for this year concluded yesterday. All of the notifications, the government has made all notifications to registrants in the lottery, whether or not they've been picked. For a lot of those cap lottery beneficiaries, they're abroad, brand new employees, entry level, whatever. And I'm seeing a lot of chatter on listservs about folks asking questions about when the fee has to be paid, how it's paid, and all of that. So I suspect that number of 70 employers is going to go up over the next several months because all of those H-1B petitions for anybody who is picked in the lottery, all of the H-1B petitions have to be filed by June 30th. So that means that if an employer, if a petition is subject to the fee, the employer is going to have to pay that sometime in the next 3 months. So we may see those numbers shift a little bit. Very few healthcare employers register folks in the lottery for healthcare workers. It's, a much smaller number than, other industries. So I don't see that as showing, I don't think there's going to be any seismic shift in the number of healthcare employers that have paid the fee by the end of June, but in the number of employers generally, there's probably going to be an uptick between now and the end of June. And then let's see. So, and then there's a question here about, I think, a concurrent H-1B, where somebody already has an H-1B and then they maybe want to come and work part-time or moonlight for another employer. As long as that concurrent H-1B is filed while the person is here in the United States and they stay in the States through its approval, then the $100,000 won't apply to that concurrent H-1B. So what I would say, and I note in this question from Nicole that the person is planning to travel, that could be a really good reason to file that H-1B petition with premium processing, or even to wait until they get back from their trip to file so that their departure from the United States isn't going to interrupt the processing of their H-1B petition and maybe inadvertently trigger application of the fee. So travel is one of those things that, as we are monitoring folks and advising folks when we're filing H's, out of a sheer abundance of caution, we're like, look, if we're filing an H-1B for you, you need to be in the United States when we file it, and you need to stay in the United States until it's approved, because we're really nervous. If you leave in the middle, there is a risk that the government is going to notice that, and they're going to say, oh, fee triggered. You got to pay the $100,000 now to get you back here. So, on a concurrent H-1B, generally the fee wouldn't apply, but that travel could be an issue. And that may be a situation where you want to counsel the person on when to travel and maybe play around with the timing of when you submit that H-1B to avoid the fee. All right, so let's talk about some other updates and other things that are going on in immigration besides the $100,000 fee, because there is so much else happening. So on the screen right now, as I mentioned, the H-1B cap lottery came to a conclusion yesterday. For the first time ever, the government considered the wage level that the person was being offered as part of a weighting system on this random lottery. So the lottery was still done randomly, but the higher the wage level, according to the Department of Labor's prevailing wage information, the higher the wage level, the more chances the person got. It was like if you had a level 4 wage, you got to put 4 tickets in the hat, right? If you had a level 3 wage, you got to put 3 tickets in the hat. And then on and on. So there were 4 wage levels. So my concern when we were going into this year's cap season was, were some employers going to inflate their, you know, offered salaries to try to be at a level 4, to try to game the system a little bit? And what were we going to see in the outcome in terms of the wage levels that were selected? So what we've seen in our firm, I can't speak for anybody else because the data hasn't come out fully yet, but what we saw internally, we had a much higher percentage of selected petitions than usual, and our selected petitions were at wage levels 2, 3, and 4. So having a level 2 wage was not a death knell for being selected in the cap lottery under this new weighted selection, which is what I was worried about. But so it's a very interesting year. We do not know how many people were registered overall. We do think demand was lower, A, because of the $100,000 fee, and B, because folks were scared off by the wage weighting. So we'll kind of see as USCIS releases its data, but at least internally, our clients had a very good year for cap selections. Personally, for one of the only times ever that I can remember, I had nobody selected, but I only submitted 3 cap registrations. Our general business team submitted hundreds, so very different outcomes there. Yeah, so anyway, that's what's going on with the H-1B cap lottery this year. Let's see if we can get to the next thing here. On that same note, I mentioned that the wage weighting was a function of the Department of Labor's prevailing wage levels. And that is a really important function in immigration law. H-1B petitions and employer-sponsored green cards through a PERM process all require an employer to pay at least the prevailing wage for the role in the geographic area where the person is going to work. In the $100,000 proclamation, one of the things buried in there was the president directing the U.S. Department of Labor to promulgate a new regulation to ensure that the prevailing wages, that the required wages for international workers were at the highest possible level. This past week, the Department of Labor published a proposed rule to do just that. It's just a proposed rule right now. It's open for 60 days for public comment. Any member of the public can submit a comment. You don't have to be a lawyer. You don't have to be an expert on prevailing wages. If your organization, looks into the rule and says, oh my gosh, this is going to make our physician wages go, through the roof, we can't afford this, it's ridiculous, or it's going to conflict with fair market value rates that we're required to pay, this is going to be a nightmare, you might talk with your government relations team about submitting a comment to the rule, because any member of the public can. And the more they hear from industry, I think the more impactful those comments are. Our organizations are submitting them. I know some immigration lawyers may be submitting directly. But when they hear from us, they think that it's just, our just personal opinion, right? But when they hear from industry, sometimes that's more impactful. I don't expect the rule to actually go into effect until much later this year or even early next year. What happens is the government has to take in all of those comments over these 60 days. They have to read them all. And then in the final rule, they have to reply to all of the concerns that were raised and explain why they did what they did. So we'll kind of see what happens. I fully expect that when this rule becomes final, it's going to be challenged in court. There's no doubt in my mind. During the Trump 1 administration, they tried the same thing. And there was a lawsuit that was successful and the rule got knocked down. So I expect that there will be a similar action this time, but filing those public comments is certainly a good way to feel like you're trying to do something, and a good way to be heard. The last thing that I think this is the last thing on this slide, is on a slightly different topic, but relates to biometrics notices and the USCIS handling of discretionary requests. This is something that started around April of 2025. All of a sudden, we started getting biometrics appointment notices related to H-1B petitions and some I-140s as part of a green card process. A biometrics notice is a notice for somebody to come in for fingerprints, a picture, and a signature sample. It's not an interview. It's basically an identity confirmation. Some of them seems random. Some of them I could tell that like my client had different spellings of their name in the past. And so maybe the government was just trying to, confirm their identity. And I was like, that's fine. But I've seen this happen a few times where a physician may have had some run-ins with the law in the past. Maybe they pled guilty to a misdemeanor. Maybe they had like a lot of traffic tickets, something like that. And I've even seen a case where my client did have a misdemeanor that he pled guilty to, paid a fine, did everything he was supposed to do like 3 or 4 years ago. And then not only did they call him in for the biometrics, but then USCIS issued a request for evidence saying, hey, your requested change of status in the US is in our discretion. And we have to know that we think that you've earned our positive use of discretion to approve this case. You had this criminal matter that you pled guilty to. Show us why that doesn't make you ineligible for this benefit. So I wrote back and I was like, well, this guy's a colorectal surgeon. He's fellowship trained. He's licensed by the state where he's going to work. He's got a fully approved J1 waiver. He's gone through 1 million background checks. He's fully credentialed at X number of hospitals and surgery centers. His one night of indiscretion where he pled guilty to a misdemeanor, like, doesn't mean that he's a criminal that isn't entitled to have his case approved while he's here in the United States. And they approved it. Because I was like, he literally is going to cut people open. I think we can trust him. But I'm mentioning this because one of the things we've started to do in our firm for all H-1Bs, pretty much all petitions, is we're asking folks about run-ins with law enforcement. On the H-1B petition application, in the forms, there is no question about arrests, convictions, charges, anything criminal. There are no questions about it. But the government is looking at this and they're not using their brains when they're looking at it. They're literally, if something spits out from their, AI-driven tools, they're acting on it. And so that can really be a complication. So we're really trying to get it, folks, and find out, like, do you have something criminal in your past? Even if it was minor, even if it was expunged, like, we want to know about it so that we can tackle this head on when we file a petition. So that's something just to know about, right? It's not anything maybe that you have to do anything about, but sometimes that can delay the approval of a case. And you may be wondering, like, why did this guy have to go for fingerprinting? I've never heard of that before. It's happening. And sometimes it's due to this, not all times, but sometimes it could just even be like a bunch of traffic tickets and they are like, oh, we want to see if this person has anything else in their background. And they'll notice them to come in for biometrics. So just be aware that that might happen. It's happening on other cases now. The government said in December that they won't, there are certain applications we have to submit photos with, H-4 EADs, green card applications, other EAD applications, work cards. The government said in December, don't send us pictures. We're going to notice you to come in for a biometrics appointment to have your picture taken. We don't trust the passport photos that you've been submitting to us for, I don't know, ever. We want to take the picture ourselves. So now we're getting RFEs in every single one of those cases where we would normally submit photos so that our client can go get a government photo taken. So that's slowing all of those cases down as well. That's a different type of biometrics notice. That's specifically for the photo itself and not indicative of any other problem. All right, moving on. This is a biggie. This is probably, besides the $100,000 fee, this is the other thing that I am discussing with recruiters and clients every single day, which is the travel bans and the USCIS benefits pause and the difference and similarities between them all. It is confusing. It is incredibly frustrating. Maybe we're seeing some light at the end of the tunnel on the benefits pause. Maybe not. I'll get to that in a few minutes. But this is something that all of you, should just kind of innately, it's got to be in the back of your mind as you're recruiting and as you're also, dealing with retention issues and anxiety that's creeping up with your, already employed physicians. This is a big part of that. So the first thing is that there were 2 travel bans that were announced in 2025. The first one came out in June. The second one came out in December and became effective on January 1st. Within those bans, there are full bans that basically prevent the issuance of any visa to any person that is from those countries. And then there are partial bans that eliminate immigrant visas, which are green cards applied for abroad, and FMJ and tourist visas. So depending on the country, there are 39 countries that are now covered by these bans. And depending on the country, you may have a full or a partial ban. To give you an example, Haiti is a country that has a full ban. Nigeria is a country with a partial ban. So Nigerians theoretically can travel and get H-1B stamps. And I say theoretically because they're still going to have a lot of scrutiny. Haitians cannot get any visa to come to the United States. And even for folks, well, we'll get to that in a second, but it's, total and complete ban, for the folks on the full list. As I mentioned, 39 countries. If a person was, let's say, born in Syria, but their family, when they were like 2 years old, moved to Canada, they're all Canadian citizens now, the travel ban doesn't apply to them because they have dual citizenship in a country that's not banned. So long as they use that passport for travel to the United States, they should be able to travel without a problem. I do know that that some of those folks, especially people born in Iran or Yemen or some places like that, where they're going for visa stamping on their non-banned passport, they're still getting held up in security checks. So it's not a free pass, but it does mean that those people aren't necessarily subject to the travel ban. Sometimes you have folks that already have a valid visa that was issued before the ban went into place. Like you hired somebody from Haiti 2 years ago, their H-1B visa is still valid for another few months, and they're like, I really want to go travel. And you're like, okay, well, they already have a visa, so they don't need to apply for a new one. As long as they come back before that visa expires, they're good, and then we'll extend their stay. And, that's a tried and true strategy that we've used in the past. But right now, my huge concern with doing that is that when the person leaves the United States, pretty much as soon as their feet leave our shores, the U.S. Department of State might be taking steps to revoke that visa, meaning that now they're stuck because they can't get a new one to come back. So for my clients that are subject to the full bans, I'm telling them not to travel even if they have a valid visa. And for the people in the partial ban countries, I'm warning them about the potential for extreme delays in getting a visa issued, even though that type of visa isn't, they're on an O or an H or something that's not specifically banned, still can, cause lengthy administrative processing. So for those folks, I still think super risky to travel, even if the technicalities in the travel ban don't apply to them. So then there's this other thing, right? So that's the 39 country travel ban. In January, the government then issued, the State Department really issued this immigrant visa ban that applies to 75 countries. Some of the 39 are in the 75, but not all of them. Like Venezuela is in the 39, but not the 75. But there's a lot of overlap between the two. When the news reports first came out about this immigrant visa ban, it made it sound like all visas were being banned, and it was super scary. I remember I was on my way to a wedding in Mexico, and all of these reports were coming in, and we were like, I was on my email the entire flight, like trying to figure all of this out. And there were a bunch of other immigration lawyers at this wedding, and we were all like trying to deal with this through the whole thing. When the ban actually came out, we realized it was not as dire as we worried it would be. Immigrant visas, as I mentioned earlier, are green cards that are applied for outside the United States. That is what this applies to. And the basis of this is that the government thinks that pretty much everybody from one of those 75 countries has the potential to become a public charge in the United States. In other words, that they're going to need public benefits, welfare benefits, if they settle in the US. And so they've made this broad brush decision to just pause the issuance of green cards to people from those countries. The travel bans are security related. The immigrant visa ban is financial related. But the immigrant visa ban does not apply to H's, J's, F's, O's. Like it doesn't apply to any of that. It's just the green cards, and just green cards applied for outside the United States. Does not apply to green cards that are applied for inside the US, which is going to be the majority of the folks that are working for you all. So in my practice, the immigrant visa ban has not been super impactful. The travel ban has been more, and the thing that's really been impactful is the USCIS benefits pause. The benefits pause was announced in early December by USCIS. It was actually announced publicly under pressure because I think they started pausing things before that, but didn't tell anybody. And there was a big clamoring, and so they released this policy memo that basically said that if somebody was born in or is a citizen of any of the 39 countries on the travel ban, that USCIS was just going to pause any decision on any case that was filed for them. It's broader than the travel ban, right? We said with the travel ban, if you're a dual citizen with a non-ban country, I gave you the example, somebody who's born in Syria but is a Canadian citizen, travel ban doesn't apply. But the benefits pause does. It is much broader. It only applies to the 39 countries. So we have folks who have J1 waivers, H1Bs, adjustment of status, I-140s, EAD applications. I mean, you name it, we have clients whose cases are just sitting. There are multiple lawsuits that are pending challenging this pause and challenging the travel ban overall. Our law firm is involved in several of them. We are onboarding some new ones. There are people who have filed individual lawsuits on this. There are other law firms also preparing litigation. This is a big problem. And the later we get into the 2026 academic year, the bigger the problem it is, right? Because we have doctors who need to start work this summer, and I can't tell their employers what we expect in terms of timing because USCIS hasn't told us what to expect in terms of timing for this benefits pause. Yesterday, I was like, ooh, I could put this in my slides. Yesterday, a memo came out that is a bunch of gibberish. It basically says that they're lifting the pause specifically with regard to some refugee and asylum related cases. And then it says they might do some other stuff. So what I take from the memo, and I must have read it 4 or 5 times because, and I even took this one paragraph and I sent it around to the lawyers in my firm. And I was like, I have read this multiple times and I don't think this says anything. Can you all read it and tell me what you think? And it really doesn't say very much. What it sounds like to me is that on a case by case basis, we might see some of these cases start to go through. We have no idea why or who or from where or when. They did not provide any of that level of detail in this memo. It's a bunch of gibberish. It's like word salad. But maybe there's a little bit of brightening, right? Maybe I don't think there's a light at the end of the tunnel, but maybe it's just getting like, maybe they turned the lights on so we can see a little better. So not a huge reason for optimism, but maybe just a little bit of movement. So we'll see what happens there on the benefits pause. This is the thing, though, as I mentioned, right now that is incredibly frustrating for our clients, and really kind of working with folks individual by individual, client by client, to figure out exactly how we want to handle the cases that we have in front of us. And I should mention with the benefits pause, we can file all day long. And sometimes filing an application gives somebody a benefit. If I file an H-1B extension, it automatically extends that person's ability to work for 240 days. I'm going to file that, right? If I file other petitions, that may give the person the ability to stay in the US and wait this out, even though they can't actually work until their petition is approved. So there could be reasons to file, even though we know we're not going to get an immediate adjudication. And then there may be cases where we're like, what do we, but that doesn't always end the inquiry, because even though I can keep somebody here, if they can't work, are they able to support themselves? How long can they support themselves in the United States without working? Is there going to be a point in time where they're like, I got to leave? And the problem with that then is if you're dealing with an H-1B situation, if they leave, we then may have $100,000 problem. So we're really kind of, in some of these folks and some of these cases, we're really squeezed and the strategy is really tough. And it seems like right now, the only way to get an individual through this morass is to sue. And the individual may be able to sue. It doesn't necessarily have to be your organization, but that seems to be the only way to get somebody's attention on this stuff. Okay, so that's the travel bans and the benefits pause. As I mentioned, with the $100,000 fee, these are the things that are just the two biggest thorns in my side every day. And probably things that you're seeing in your organizations every single day. Let's talk about some other stuff that we'll be able to get through a little bit faster than these few topics. All right, I already mentioned some of this, but I want to go back and talk about some risks of travel. I get asked a lot by my clients, what do we do with regard to travel? When a doctor comes to us and says they want to go home and see grandma, see mom, visit their family, go on vacation, whatever it is. It is a really hard question, right? I mean, I was born in the United States. I've lived here my whole life. Many of you may have, the same background. It's really hard for me to tell somebody not to go visit their family when I know I can hop a plane and in 2 hours I can be in Minneapolis where my family is and go visit them. So it's hard for me to tell folks don't go, but there is a lot of risk involved in travel right now. And so I have been strongly discouraging folks from going, if it's just, unless there's like an emergency, obviously, go see a sick relative. I don't want to keep somebody from doing that, but the risks are real. They're not hypothetical. And so people really need to kind of think about, what they're willing to undertake. And I also tell physicians to be really clear with their employer when they are going to travel. What are the dates? When are you leaving? What is your anticipated date of return? Are you applying for a visa while you're abroad? Because there could be delays with that. And to keep in touch while they're abroad. So that, if you do have to loop in emergency coverage because they're delayed in coming back, you at least are on notice that might be a necessity. And by the same token, I've talked with employers about like wanting to travel home to visit family is not a personal failing. It's not a bad thing to have, physicians employed with you who are close with their family. So, you can't blame them if they go abroad and there's some delay that was outside their control. I think addressing that with some compassion is important, but also, being realistic about what's going on as you're trying to set policies and you're communicating with folks, trying to have them understand things are not like they were a couple of years ago. They just aren't. The rules are different. The attitude of the government is different. And so even though they might have traveled before and it was no big deal, and they're like, oh, I've been millions of times for a visa stamp. It's no big deal. And then they go and their visa appointment gets canceled, their visa gets revoked, there's some problem. It's like they need to really understand what the new situation is. So one of the new rules is that every applicant has to appear for an in-person interview in their home country. This includes children and it includes people over the age of 65. With the disruptions in the Middle East, they may be able to go to an alternate post. And there are times where it's just not feasible. Right now, there are like no appointments for visas in India. There are appointment scheduling issues in Australia. There's all these different issues going on around the world. If your, physician has to, maybe they're speaking at some kind of international congress, international, conference or something, and they need to be in a particular country. If they reach out ahead of time, they may be able to visa stamp in that country. So there's a little bit of individualization going on at the consular level, but this is a real policy, and the Department of State is applying this very, relatively strictly to apply in the home country, and to have the in-person interview. There's no more Dropbox or just, mail in your documents or whatever. Everybody has to go for an interview. As I mentioned earlier, The government has had a huge increase in visa revocations. So typically if somebody's in the United States, the visa stamped in their passport, which is what they need to enter the US, won't get revoked while they're here, absent very specific circumstances. Once they leave the US, all bets are off. If there's some kind of criminal history, if they're from a travel ban country, if, who knows, there could be all kinds of reasons. There's a risk of visa revocation. And if the visa is revoked, they're going to get an email notifying them they won't be able to board a plane home until they have a new visa. This isn't something that's happening to everybody, specifically with people with criminal history, specifically for people from travel ban countries. I think those are the two groups that have the biggest risk. But it is a risk, and it's something to know about. This is something that was just not happening before. When folks go for visa interviews, their social media vetting, they have to set all of their social media accounts to public for H-1B, H-4, J1, J2. So this includes, the primary and spouses and children, have to set all of their social media accounts to public so the government can go in and scrape their entire online presence. A report is prepared for the consular officer to review with recommendations, red flags, things like that. That's one of the things that has caused the consular system in India to just go haywire. They just are recently expanding to cover more visa categories. It's debatable whether that's going to cause delays in other places, but it's an issue. So I don't like to tell people to censor themselves online, but the government's going to be looking. I find this is particularly offensive for H-4s, which are spouses and children of H-1B visa holders, because, an H-4 teenager between the ages of 13 and 16, who's going with their parent to apply for a visa so they can come back and go to school, has to set their Instagram and their TikTok and all of that to public. And I personally, as the parent, and everything, just find that to be horrifying. That even for a month, 2 months, 3 months, right, their social media has to be public in order for them to get a visa. So this is really impactful for travel. The other reason why travel is risky is because we have literally no idea what else is coming down the pike. In the last travel ban that came out in December, the government said that they would revisit it in June of 2026. So could there be another update to that in June or July or whenever? Yeah, there could be. We don't know what that's going to be. We don't know when it's coming. I don't know if there's going to be other stuff that comes down from the State Department that affects people's ability to travel. So, sometimes we only get 24 to 72 hours notice before a policy goes into effect. So, and it may not be possible to get back here before then. So there could be really, there's just that uncertainty reason to try to avoid unnecessary travel. A few things with regard to J1 waiver updates. And I'm just going to talk about the federal agencies. There are some things going on there. Overall, the J1 waiver process is unchanged. Exactly what you were doing before, you are doing now. There have been updates. The government did review a bunch of underserved areas. They're proposing to withdraw a bunch of underserved designations. So that may affect individual employers in that regard. But in general, the system, the process we go through for J1 waivers is just like it's always been, right? Thank goodness. But there are a few weird little things going on. The ARC, the Appalachian Regional Commission, announced very quietly about a week or so ago that they are suspending their program from May 1st, 2026 to around October 1st, 2026. Even cases that arrive at the ARC in advance of May 1st, if they're still pending there on May 1st, they are not going to touch them until October. This is the longest suspension of the ARC's waiver program I've ever seen. Many years they would suspend for like August and September so they could attend to other things over the summer months. But yeah, they're not going to do any work for about a 5-month period on J1 waivers. And it's frustrating because these agencies have unlimited waivers and typically no deadline to apply. So they can be a great option for a doctor who maybe just found out a month ago they didn't get their Indiana waiver. Now they're back in the system and they want to go for the ARC, and now that's really foreclosed for them for the end of this year. So very important to know about that. The SCRC, I didn't put it in the slide. They're running a little bit slower than usual. They usually recommend waivers within 3 to 4 weeks. They're at like a 60 to 75 day time frame now. Ours are coming at about 60 to 65 days. They're still very supportive. This is not indicative of a resistance. It's mainly because with the government shutdown, they lost some resources and coming back online was really challenging. They just had a lot to get to. And so they're just a little behind in processing, but still as lovely as ever to work with. And then the last one I wanted to mention was HHS. For those of you who may have pending HHS waivers for your candidates, you may already know some of this, but without really saying, HHS was affected by the government shutdown that happened in the fall. All of the people who worked on the program were furloughed for October and half of November. When they came back from that, they worked up all of their cases. They had a lot of those cases ready to go by sometime in December, January. They had another little blip of a shutdown for about a day in January. And then a bunch of us started noticing that our cases we filed in October were just sitting. They hadn't come through, no recommendation. At some point in February, we heard that they had paused making recommendations on pending applications and that they were going to be revamping their rules and that they wouldn't recommend any waivers until the rules had been revamped and the new rules would apply to the pending waivers. Well, you can imagine what that did to a bunch of attorneys, hundreds of us nationwide who were like, what are you doing? So there's been a lot of advocacy from our end with HHS, a lot of conversations. I know I've had clients whose government relations folks have reached out to high levels at HHS to say, like, this is just not okay. We need these doctors. They're signed, like, we need them here. About a week ago, we found out that several of our long pending cases had been recommended and had reached the State Department, which was great. And a bunch of folks around the country had the same experience. Haven't necessarily seen all of our cases make it through, but I do understand they had about 200 cases pending. So they're just trying to work themselves through that backlog. We still are filing a few cases because we don't have alternatives for certain folks. And so we're still filing with HHS. I firmly believe that their program is going to see rule changes over the summer that will apply as of October 1st. I don't know what they're going to be, but we may see some big changes in the HHS waiver process for the fall. And so we're all kind of staying attuned and checking on that pretty regularly. So that's been our big, probably the most impactful delays on J1 waivers have come out of that program. And then finally, alternative licensure pathways. So these pathways that some states have enacted to allow international medical graduates an easier way to get licensed in the state without maybe having to go through all 3 steps of the USMLE and a full residency and fellowship. They're very well intended. As you can see, 19 states have enacted pathways, 22 have proposed state new rules. The Federation of State Medical Boards, the FSMB, has a really fantastic document that you can Google online that lists out, it was just updated recently, and it lists all of the states that have these, that all of the states with proposed rules, what the status is, what all the details are about them. So that is a really fantastic resource. I consult it pretty frequently. But it's really important to know that licensure eligibility and immigration eligibility are not the same thing. To be eligible for an H-1B, for most people, they need to have passed all 3 steps of the USMLE. And most of these programs, most of these pathways do not require that. And so a lot of the doctors who go through the alternate licensure pathway are not necessarily eligible for H-1B sponsorship. I find that these programs are really most usable by people who maybe won the green card lottery. Maybe they got a green card through marriage to a US citizen. Maybe they were granted asylum, years ago. Somehow they got here and, through a non-physician related pathway. And so they're here, they've got a green card, they have some kind of status. These alternative licensure pathways are great for them. For our typical folks that come here on a visa and do a residency or fellowship, they're already on that pathway and they're going to follow it. But bringing folks in directly from abroad to take advantage of these pathways, you're really looking for someone who's maybe eligible for an O, right? Somebody at the top of their field who's got a great name for themselves, maybe a fully successful career abroad before they come to the US. Those folks are the ones you really want to look at for like this kind of thing, because of the disconnect between the license rules and the immigration rules. These rules vary on like almost every topic. Like J1 waiver, how we always talk about all of the programs vary, they're all different. It's the same thing for these pathways. I think like there may not be any two states that have the same law. So, what steps of the USMLE do you have to pass? How much supervision, the type of facility the person has to work in, how long they can get the license for. Do they, become eligible for a full license eventually, or do they always remain on something more limited? All of those things vary depending on what state you're in. So it's also important to be aware of that, that it's not a one size fits all kind of thing, the way the states have gone about doing this. But, maybe someday we'll get some relief on the immigration side to match up more with these. But yeah, that would take an act of Congress. So I've already expressed my my skepticism that that's going to happen anytime soon. But yeah, that's all I have. My contact information is on this last slide. If there are any last minute questions, I'm happy to tackle them. But otherwise, I really thank you for your attention. I thank you for the information and the questions that were shared with us. And please let me know if I, can be of assistance.
Thank you, Elissa. This was great.
See. Have a great day, everyone.